Last week, the United States Supreme Court announced it would take a case called Friedrichs versus California Teachers Association, which challenges the constitutionality of public sector forced unionism. The court's decision to hear Friedrichs is an important step towards finally respecting the First Amendment rights of America's public servants. A victory in Friedrichs would overturn a 1977 Supreme Court precedent laid out in Abood versus Detroit Board of Education. In Abood, the court's majority held that non-member employees could not be forced to pay fees directed towards political activities or lobbying, but could be forced to pay fees directed toward union bargaining. However, for public employees, their employer is the government, meaning that bargaining is itself a political activity. The 10 California school teachers, represented by the Center for Individual Rights, who brought the challenge in Friedrichs, argue that their First Amendment rights are violated when they are forced to pay compulsory fees to support union bargaining with the government involving issues they do not support or agree with. Two recently won foundation cases decided by the court began to dismantle big labor's forced dues-funded empire in the public sector and paved the way for the court to take up the Friedrich case. In Knox versus SEIU, the court held in 2012 that public sector union officials may only extract special assessment fees from their non-members with their affirmative consent. In 2014, the court held in Harris v. Quinn that non-union Medicaid-funded home health care workers, because they are not full-fledged public employees, could not be forced to pay fees to a union. However, the court stopped short of overturning Abood in both cases. The question of whether teachers and other government employees can be required to subsidize the speech of a union they do not support as a condition of working for their own government is now squarely before the court in Friedrichs. The American people overwhelmingly support the principle that while individual employees should be free to join and pay dues to a union if they so choose, no one should be required to do so. This position is fully in line with the First Amendment protections for free speech and freedom of association. Millions of America's public servants will be freed from the shackles of compulsory unionism if the court builds on last year's Harris decision and ensures that no public employee can ever again be forced to pay union dues to get or keep a job. But until that time, the National Right to Work Foundation will continue to provide free legal aid to any public employee who has suffered workplace abuse as a result of compulsory unionism.